Sometimes we have to get a little geeky and step back, slow down, and talk about some big picture concepts so you can really understand Second Amendment litigation. We're going to do that today. We're going to talk generally about the difference between liability and remedies. In particular, we're going to talk about remedies because it doesn't matter if you sue the government to win your right to keep and bear arms if you don't get the proper remedy. And what is a remedy? It's what you want the court to do for you to protect your rights. Let's talk all about this when we get back to make you the smartest person in the room. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. And if you have a copy, feel free to leave a review on Amazon. Always interested in what people have to say about my scholarship and work. Good, bad, and ugly. All right, folks. So I want you to understand, and this will be helpful for you not only in understand Second Amendment litigations moving forward, but also when you read the newspaper. So I want to make you smarter than the ordinary journalist, which I know is not necessarily the highest standard on the planet. But it's very important that you understand these basic things as you think about legal cases. We're going to talk about civil cases and a little bit on criminal cases as well, because the concepts are really the same. And what do I mean by that? What I want to talk about is the difference between establishing liability, meaning that the government has done something wrong or is about to do something wrong, and the remedies as a consequence of that. Mostly I want to talk about remedies because it's very important for you to be the smartest person in the room to understand what remedies are available to you, or to the citizen who has had their rights violated by, let's say, the government. A lot of people like to talk about my rights have been violated, but what does that mean? And most importantly, for the purpose of this video, what can you do about it? Meaning, what can you get back from government to protect your rights? So to begin with, let's understand in the context of a typical Second Amendment lawsuit or Second Amendment litigation, which you guys all track, there's two components to it, at least two components to it. The first is you have to establish that the government has done something wrong or will do something wrong if they enforce a law. This is often referred to as the liability or the merits of the matter. Liability or merits of the matter. The way this works, of course, and this is what we spend most of our time talking about, and that is that the courts have to define the scope of the right to keep and bear arms. They have to define the text of the Second Amendment, and so on and so on. And then after they've defined the scope based on precedent, history, the text, and so on, they then take that interpretation or that meaning of the right to keep and bear arms under the Second Amendment, and they apply it to the modern case, the modern controversy involving you or some other Second Amendment proponent, let's say. And then they determine whether or not the government has violated the right of the people to keep and bear arms, violated the Second Amendment, or violated some other constitutional or legal provision. That is often referred to as the liability part of the case, or sometimes it's referred to as the merits part of the case. That's fine. Now, I want to talk mostly about this in this video. I want to talk mostly about what happens if there is a determination that the government has done something wrong in violation of the Second Amendment or is likely to do something wrong in violation of the Second Amendment. What remedies does a Second Amendment proponent or Second Amendment litigant have as an option? And I want you to understand these remedies. And if you do a lot of this, you may want to take notes here or reflect on this because it could help you in your writing or discussions or op-ed discussions or writing or blog posting or whatever you do to understand the fine distinctions I'm about to make here. So there are different types of remedies. The most obvious one that we often see in legal cases around America, but we don't see it a lot in Second Amendment cases, are money damages, which means if the government has done something wrong to you, you can sometimes sue them for money damages. And if you can show that you've been financially harmed, you can ask for money damages, and the court or a jury may award you a amount of money that says that your rights have been violated, you need to be compensated to the tune of $10,000 or $100,000 or whatever it may be, monetary damages. Now, this doesn't come up a lot in the context of current contemporary Second Amendment litigation because dealing with damages often delays cases. And what I mean by this is now you have to have a big litigation involving how much money you've lost or the financial damages you've suffered. And sometimes that's very hard to prove in the context of a Second Amendment litigation because, again, if you've been denied the right, for example, to acquire an AR-15 for the last 5 years, how have you been financially hurt? It's very difficult to measure that because, again, what have you lost? You've lost the opportunity to use the gun, but they're going to come back and say, we've actually saved you money because we denied you the ability to have the AR-15. We've saved you all that money that you didn't have to go to the shooting range, you didn't have to buy ammunition, and so on and so on. So rather than get into these back and forth, and there's some other technical reasons why monetary damages are difficult to pursue in the context of a Second Amendment litigation, but this is the first basic one. But we don't usually see that. What we usually see in Second Amendment litigations is, of course, what are known as injunctive relief. Injunctive relief. Now, there's three general types of injunctive relief, and this is where we're going to be a little nuanced just to help you out. There are three sorts of injunctions as a general matter under the category of injunctive relief. Again, the first major category is monetary damages. The second one is what we usually see in Second Amendment litigations, and that is injunctive relief. And there's three types. The first is known as a temporary restraining order. The second is known as a preliminary injunction. And the third is known as a permanent injunction. A temporary restraining order, or TRO, a preliminary injunction, or a permanent injunction. How are these three things different? And the answer is they really arise in different times during the life of a litigation. Specifically, a temporary restraining order, or a TRO, can be entered between the time that a lawsuit is first filed and the date on which a court hears and makes a decision on whether or not a party is entitled to a preliminary injunction. Hear what I just said? The TRO, or temporary restraining order, is the kind of relief where something could be enjoined, which means the court comes out and says, you may not do something, or you must do something, whatever it is. We're telling you to do something, or we're telling you as a court not to do something in the form of a temporary restraining order. That is where you have injunctive relief between the time a lawsuit is filed and the time there's an actual hearing and decision on whether or not a preliminary injunction should issue by a court. So what is a preliminary injunction? A preliminary injunction is what we often see in the context of Second Amendment litigation. And what this is injunctive relief that is entered, or not, but it's entered on behalf of, let's say, the Second Amendment plaintiffs from the day of a preliminary injunction hearing, and that relief or injunction will continue until the very end of the lawsuit, the very end of that case. So the TRO is between the start of the case and the time you have a preliminary injunction hearing, and the preliminary injunction, if it's entered at all, will be entered from the day of, let's say, the preliminary injunction hearing or the decision on the preliminary injunction. And that is, if it's granted, will continue as a general matter until the very end of the case. And then what happens at the end of the case, after all the discovery is done and all the investigation is done and all the litigation is done? At the end of the case, you get to the third kind of injunctive relief, and that is known as a permanent injunction. And a permanent injunction is part of a final judgment, and a permanent injunction is something that is what it says it is. It's permanent. It will last after the case is over. So the TRO is from the start of the case to the entry of a preliminary injunction. A preliminary injunction is from the day it's entered through the end of the lawsuit. And then a permanent injunction continues from the day the lawsuit ends until far into the future. So if you have a permanent injunction, for example, let's say in the Bruin case in New York that says New York may never ever again use a may issue permanent regime of the sort they were using before NYSERPA versus Bruin was decided by the U.S. Supreme Court, a permanent injunction could issue that says the state of New York may never, ever, ever do this again. And if they do so, it will violate the permanent injunction, and they could be, for example, held in contempt of court. So those are the three types of injunctive relief. Now, there's another type that we sometimes talk about. In fact, actually, we really don't talk about it a lot in the context of the Second Amendment. I think I might be the only person to do it, but I probably should do more of it and get more and more people thinking about that. And that is what is known as institutional reform litigation. Institutional reform litigation. Now, what is this? Now, institutional reform litigation is something that the federal courts have often been involved with, involving, let's say, prison overcrowding, prison conditions, mental health hospitals, their conditions of living in a mental health hospital, school segregation cases. Now, what this is with institutional reform litigation is a court could step in at the request of a party and start to oversee with a monitor, for example, a particular institution. It could be a company, it could be an organization, but usually it is a government agency that has screwed something up and has been found to have systematically violated their rights or somehow otherwise screwed something up so badly that they were violating the rights and liberties of Americans in some terrible way that the court felt the need to enter various forms of injunctive relief and appoint a receiver and or a monitor, which is a person that kind of oversees. It could be a referee, special referee sometimes, and they oversee the company, the organization, or the government entity, the government agency, and basically says, we're going to watch you very carefully for the next couple years to make sure you follow the law and don't screw this up. And if we hear back from the monitor, the referee, whatever it is, that there's an issue, we're going to, they're going to report back to me, the federal judge, and we're going to check this out. Now, this was very popular among the left for many decades, especially in like desegregation cases, like in the Kansas City, Missouri school district. We had a federal judge there literally oversaw the Kansas City school district there in this sort of institutional reform litigation. Now, how this might conceivably apply in the Second Amendment context as I've envisioned it in the past is, let's say you have a police agency that goes rogue and simply does not respect the right to keep and bear arms. They refuse to issue permits for Second Amendment events. They refuse to issue concealed carry permits. They refuse to issue purchase permits, whatever it happens to be. They simply repeatedly violate the right of the people to keep and bear arms. And you could, in theory, use institutional reform litigation to have a federal judge oversee that agency. I should note, kind of an example of this metaphorically is for those of you following the NRA litigation that was going on involving the NRA organization. There was a debate there as to whether or not New York's Attorney General Letitia James was requesting that some sort of a receiver or monitor, special referee, I'm not sure exactly what the term they were using was, would be appointed to monitor the behavior of the NRA to make sure the NRA complied with the law. And I believe that was rejected by the judge involved in that state case. But that's kind of a metaphor of what could be viewed as an institutional reform litigation, although I think that relief in that case was denied involving the NRA. But that's the sort of thing that has been granted in, again, these other contexts where a prison system simply doesn't respect the rights of the inmates, and a federal court gets involved to monitor to make sure that going forward that federal prison system does respect the civil rights and liberties and rules and regulations of the road for handling, let's say, prisoners. And the last thing I want to mention here is attorney's fees. This is the last kind of remedy just to make a mental note of. And this is not a remedy as a general matter that you plaintiff directly benefit from. This is usually applied for by your attorneys under federal law, civil rights law, 42 U.S.C. 1988. That's 42 U.S.C. 1988. It's the attorney fee provision. It's to encourage attorneys to take cases that they might not otherwise get paid for a variety of reasons. Maybe there's not enough financial incentive to do so. So under 42 U.S.C. section 1988 of the federal code, attorneys can bring these sorts of lawsuits, and if their client is a prevailing party, then they can apply for their attorney's fees. Now, conceptually, this is a very good idea to force the government to pay your attorneys for vindicating your civil rights, including your right to keep and bear arms. So conceptually, it makes a lot of sense, but there's a practical problem here that I've noticed, and I'm very familiar with attorney's fees. Being a New York Wall Street lawyer, trust me, attorney's fees, I'm quite familiar with getting paid. I've seen lots of big bills, very large bills, and everything else over the years, so I'm quite familiar with attorney's fees. But so there's a practical problem, though, when you're dealing with Second Amendment litigation, and the practical problem when it comes to attorney's fees and Second Amendment litigation is this. Just think about it conceptually for a moment. Where are you on behalf of a Second Amendment organization suing? You're generally suing in terrible anti-gun jurisdictions. You're suing in New York City. You're suing in New York State. You're suing in California. You're suing in parts of Illinois that are crappy when it comes to our right to keep and bear arms. And these judges, not always, but often, they bubble up through the system and get blessed by Chuck Schumer or Kristen Gillibrand. They're part of these political, these anti-gun political spaces like Gavin Newsom is in. So you get judges that don't like the right to keep and bear arms. So when there's a successful Second Amendment win, guess what? will those judges be overly generous toward the lawyers, or will they be, let's say, cheap and churlish? And in my experience, when it comes to collecting attorney's fees in Second Amendment cases, it is not the sort of thing where attorneys are going to get rich in any respect, because those courts in those terrible anti-gun jurisdictions are going to look for ways to really screw over the plaintiffs and their attorneys and deny them money, because they frankly didn't want the Second Amendment people to win, and they don't want to fund the Second Amendment movement. That's a practical reality which I don't support, but that is the reality on the ground. You're much better off getting attorney's fees in other ways. But again, that's just something you should be aware of as you reflect on remedies that you or your lawyers can prevail on and get in the context of suing or bring in Second Amendment related cases. The only other thing I will mention, obviously this doesn't deal with criminal cases. Usually the remedy you get in a criminal case, if you win your right to keep and bear arms Second Amendment challenge, is the indictment, the criminal complaint that's been brought against you. Some or all of it will be dismissed. So your reward, i.e. your remedy in the context of asserting the Second Amendment challenge in a criminal case, is the criminal charge or charges against you will be dismissed and dropped with prejudice, which means they go away. And that is the remedy you get if you win a Second Amendment challenge to a criminal indictment or criminal complaint brought against you involving gun charges. But again, that's not the routine, but that does occur, and that is the remedy you'd be looking at, a dismissal of the indictment or criminal complaint in a criminal context, analogous to, of course, the civil thing we've already talked about. All right, folks, well, I hope you learned something here today. I know it's not breaking news or anything, but I still thought this was important to go over so you could have a big picture understanding of the difference between liability of cases and the remedies. And remedies are extremely important because it doesn't do any good to go out and win a case if you don't get what you ultimately want. What is the point of spending years fighting the government if you don't ultimately get what you want, which is, for example, the right to keep and bear arms to be vindicated, and you to get your concealed carry permit, or you to be able to buy your AR-15 or whatever is the relief that you're seeking. All right, so there you have it, folks. Make sure you follow me on X at @4boxediner. Don't forget to like this video and subscribe, and we will see you again very soon here, I hope, at the 4 Boxes Diner.
Orders up. Table 2A.